Can one fight a guardianship order? My name is Goldman. I'm the director of Goldman & Associates. Our firm has a primary focus on family law issues here in the state of Michigan. And today we're going to continue our video series designed to educate and inform the public. So please subscribe to our channel. The question of guardianship comes up because it's kind of something that comes up in a family, and it may be relevant to the guardianship of a parent or may be relevant to the guardianship of a child. So therefore, it's appropriately both a probate issue and a family law issue. I guess the answer is yes. You can file a petition to terminate a guardianship. That is to say, you can prove before the court that whatever conditions existed that supported the guardianship no longer exist. And therefore, the guardianship isn't necessary. And therefore, the court should dissolve the guardianship. You're going to have to show, though, that if you're dissolving, let's say, a guardianship on yourself, let's say you're the ward, somebody has guardianship over you, you're going to have to show the court that you don't need it, that you are able to take care of your own personal needs, your own financial needs, whatever the guardianship was designed to address. You're going to have to be able to show the court that it's no longer necessary because other things have happened, and now you can take control of that. The court will end the guardianship of a child, but only if it feels that it's in the best interest of the child to do so. So therefore, the child may come before the court, may hire their own lawyer, and they may say, I want this guardianship on me dissolved. In that case, a lot of times the court will dispatch a guardian ad litem to address the interests of the child, or may otherwise take testimony on whether or not the court still needs a guardian. We see a lot of these with celebrity children, where the parents are the guardian, and all of a sudden the child alleges that they don't need the parents, that the parents are controlling the money, that the parents are stealing the money, whatever it may be, and therefore they want the guardianship dissolved. And sometimes the courts will agree to that and allow the child to be emancipated, allow the child to control their own money, or maybe take the guardianship or the conservatorship, the control, out of the person that has it now and give it to somebody else. Give it to a service, give it to a lawyer, give it to somebody who the court regards as someone who can honestly and in good faith control the money, make appropriate decisions that are in the child's best interest. So that is certainly something that's available for the court to do. The court can also accept objections from the ward. The guy who is the subject of the guardianship can come before the court and say, I don't need a guardian. My kids say I need a guardian, but that's just their way of controlling me. I get along fine on my own. I do this, I do that, I do the other thing, and then the court can determine whether or not the person in fact needs a guardian in the first place. I've many times seen the court turn over guardianships and say, you know what, I'm dissolving this. I don't see any reason why you can't take care of yourself. You're in good health. You live alone. You lived alone all this time. You don't need this. And the court does have the ability to set it aside, but obviously every case is different. If you have questions about your case, reach out and we'll be glad to help you out.
248-588-3333. 248